Hi, in this video we're going to discuss denials of liability, and this is something that we deal with in chapter 13 of the textbook. So these are rules relating to intoxication, to automatism, and to some extent to insanity. Now, we split these issues that we call denials of liability, we split them from the chapter on defences, which is chapter 14. Now it's first of all important to realise why we've done that, because a lot of the time they're analysed together, and you'll often see what we describe as denials of liability referred to by courts and by academics as defences. Now essentially the logic, very basically, is a defence, as we use the word in its technical form, is where the defendant has committed an offence, i.e. they've completed the actus reus and mens rea of an offence, so therefore the offence is complete, and they then choose to appeal to a separate set of rules in order to exculpate themselves, in order to find a way to out of liability. So you might say, for example, yes, I killed the victim, I committed murder, or yes, I beat him up, I committed an offence against the person, but I only did so in order to save my own life because he was attacking me with a knife, therefore applying to the defence or appealing even to the defence of self-defence. Now in contrast, the rules of denials of liability are precisely the opposite. They don't accept that you commit an offence and then appeal to a separate set of rules, but rather they're a way of articulating your denial of that offence itself. So just as the defendant might say, I didn't commit the bank robbery because I was out of the country, therefore I deny that I completed the actus reus, I deny that I have the mens rea. Equally, if a defendant is extremely intoxicated, they're using their intoxication to explain a lack of offending. They're saying, I didn't intend to kill, for example, I was so drunk I wasn't able to intend to kill. I didn't foresee the risk of damage because I was so drunk, or I was hallucinating with drugs, such that I didn't foresee the risk of damage to somebody else's property. So in this way, denials of liability are exactly that. They are not defences in the sense of a separate set of rules used to exculpate, but rather they're a set of rules that are designed around explaining why a defendant potentially has not committed an offence in the first place. Now, with having identified that sort of the difference that we're using within the textbook, it's next important to think about a couple of ways in which denials of offending are important. The first one is, as I've said, it's basically they provide a language in order to explain a particular denial of offending. So in the example I gave of intoxication, our defendant is saying, I'm not liable for the offence, I lacked mens rea because I was so drunk, or I was taking drugs, or whatever it might be. In terms of automatism, our defendant is saying, I didn't commit the offence because I wasn't acting voluntarily. My conduct was involuntary and therefore I was incapable of committing an offence. And in relation to insanity as a denial of offending, our defendant is saying, I have a defective reason caused by a disease of the mind which has caused me not to understand the nature or quality of my actions, i.e., I didn't understand what I was doing, I lacked mens rea, and therefore I lack liability. So in this way, denials of liability are a really useful way of shorthand, basically, of explaining a lack of offending, but also when we're looking at when the rules apply and don't apply, they're a very useful way of analysing what we mean by requiring voluntary conduct for a crime. The rules on automatism in particular are very interesting to identify how much control do we need of our bodies in order to say that we have acted voluntarily and therefore we are capable of committing a crime, as opposed to we acted involuntarily and therefore no crime is committed. Now that's the first way, as I say, these rules are important, but there is also a second way, and that's the fact that far from being defences, actually these rules can be used to inculpate the defendant. They can be used to build liability where otherwise liability might have been lacking. This is most obvious in relation to the intoxication rules. So basically the intoxication rules, as we describe them in the textbook and as they apply in case law, apply where the defendant says, I lacked mens rea because I was very drunk or because I was intoxicated by some other drug. And what the legal rules say is, even though you lacked mens rea, even though we recognise a lack of mens rea on that basis, if your crime was a basic intent offence, if the drug you took was dangerous and if you took it voluntarily, we're going to use your prior fault, we're going to use that blameworthy choice to become intoxicated, and we're going to use it to replace or substitute for your lack of mens rea in order to construct liability where otherwise there would be none. Now, this use of prior fault in this way is very novel, and it's novel to these denials of liability. It can also happen, although more rarely, in relation to automatism, where again, I'm explaining my lack of offending by saying I wasn't in control of my body, but if we can look back to a prior blameworthy choice, where I knew or I foresaw that I was going to become in an automatic state and there was a risk of harm being caused, then again we can use that prior fault to reconstruct liability. And similarly for insanity, not so much in terms of reconstructing liability, but where the insanity rules apply, the defendant is acquitted, but it's a qualified acquittal. You're not guilty by reason of insanity, and there can be compulsory detention as one of the potential disposal orders. So in relation to each of these rules, intoxication, automatism, and insanity, they are shorthands for denying offending, but they're also routes to either to actually recreate liability or to lead to a qualified acquittal in relation to insanity. Now, just as a final thought here, there's a couple of things to remember. The first one is that these rules are not defences. They are denials of offending, as opposed to accepting that an offence has been committed and then appealing to a separate set of rules. And another reason why that is important, and this is the second point, is that these rules, these denials of liability, can also be relevant when you're applying defences. So for example, if you're applying the defence of self-defence but our defendant was intoxicated at the time, the fact of their intoxication will also be relevant to your analysis of the defence, just as it was relevant to your analysis of the offence. So keeping this separation of the two types can be useful and helpful in applying the law. Thank you.